Welcome. The Gillian White Annual Lecture is hosted by Manchester International Law Center and the Women in International Law Network at the University of Manchester Law School. Our co-directors of WillNet are here, Ian and Yusra, as well as our director of WillNet, Emma, and our head of the law school, Javi, as well as many of our colleagues. It's nice to see everybody. The Gillian, how to talk about this? Gillian White was the first woman appointed as full professor in law within mainland Britain. And as a way to commemorate her legacy, the purpose of this lecture series is to capture innovative thinking at the frontiers of international economic law. And we've succeeded. Tonight we have Professor Anna Beckers with us, who's Professor of Private Law and Social Theory at the Faculty of Law at Maastricht University. She's written 2 books recently, one single author, even more.
No, but one was not that recent.
2015.
15,
Yeah, 2015, Enforcing Corporate Social Responsibility.
Yes, sir.
And then in 2021, again with our publishing, I forget that it was on AI and 3 theories of liability in AI, if I remember. That's right. So it's just a real pleasure, Anna, for you to be with us today. Professor Beckers, the floor is yours. The talk is Interrogating European Transnational Private Law. Welcome.
Thank you very much. So thank you very much for this kind invitation, and John, for the very kind words as an introduction. I think this is a wonderful introduction. I mean, you may wonder, I'm directly jumping into the topic, my talk is about interrogating European transnational private law, and you might wonder what type of interrogation is this going to be, because you might not know that type of concept, and the idea of my lecture is also to introduce that concept, because it's actually a concept that we have been, and I will explain this a little more in depth, and during the lecture we have been starting to develop, me and with a couple of other scholars, on to see and to test whether it may be a useful heuristic for understanding certain influences, global influences, geopolitical influences in its relation to private law that we may see these days, also maybe that we have seen historically, and maybe give us roots for new types of research. So it's very much of a concept that I'm testing here also for the first time. So it's an absolute pleasure to start off with this here in Manchester. And I think it is an interesting way, because I understand it's a lecture here that is in the context of international law. I'm, let's say, grounded in private law, but always with a bit of a feet in questions related to international law. And my idea is very much in this lecture to introduce this and to discuss whether, and later on maybe a bit wine to also discuss what can this concept do or what can it not do. And also you might wonder why I'm in the UK now. I'm invited in the UK, and I'm continuing to speak about Europe and European transnational private law, and there will be a lot of European and also EU still there, so bear with me. This is what happens if you invite someone from the University of Maastricht. It places itself as being a truly European university. But also I see this concept of European transnational private law not as one that only is about Europe, but also as a way to maybe capture phenomena that you can also apply elsewhere. So much of the argument that I'm putting out there is sort of the linking, instrumentalizing of private law also by different states and regional organizations in gaining global influence. And this, of course, is something that you cannot only, or that you can also interrogate from other perspectives. But here, I think the European is also a way to ground it and to do a start in terms of providing one perspective. But of course, you can also discuss Chinese versions of private transnational law, and also how or US versions of private transnational law. And I guess also UK versions of transnational private law, which still is a bit of a pain for me to not consider the UK in that case as part of the EU. I hope that it also might resonate with the public international lawyers. And yeah, so to start this off, I'm always trying to give a little bit of a quote, or in a case. In this case, it's more of a quote, which I find quite intriguing. Which is a quote from the press release from the European Commission from its trade strategy in the middle of the pandemic, 2021, which has a lot of interesting aspects. Where the EU Commission has been setting out its new trade policies, and its focus in its trade policies. Calling for its concept of open strategic autonomy and our commitment to multilateralism, but already this strategic autonomy move, so this idea that Europe needs to have its own autonomy in its trade relations and also secure this. So one aspect, and that will come back as well, is this sort of creating its own strategic worlds through trade. The other one is as well as also the recovery through support for the green and digital transformation. So the strong employment of trade also as a means to export what the EU, the Commission, what Commission President Ursula von der Leyen has coined, this value-based idea of exporting European values. So that as well, and then the last sentence, which I highlighted a little bit more, where necessary, the EU will take a more assertive stance in defending its interests and values, including through new tools. And these new tools is what I want to focus on, because that is something that I, as a private lawyer, am very interested in, to see how private law is becoming part of this toolbox. So not only trade law, let's say classically understood, law and participation in international trade organizations, also trade agreements, but also through private law rules trying to attract foreign disputes to its own territory, but on the other hand, using private law tools and private ordering as well, contractual to export its own values. So this is, let's say, the context that I started with, and to give you, let's say, the context, the building blocks of where I locate this concept of European transnational private law. So you might have heard, let's say, this discussion on the EU as a global regulator, which Anna Bradford has coined very prominently, which I think was one of the books that assured the Europeans that they still have a say on a global level, so for better or for worse. Who made very strongly this argument that the EU, through regulation, through also being a global regulator, is changing and is transforming also the global regulatory landscape, including in other countries. She has been coining this de facto and de jure Russell's effect, not indicating that by conditioning internal market access to a certain set of regulations, you have a strong, let's say, impetus for and incentives for global corporations to adopt these standards worldwide and hereby export. One of the classical examples is the General Data Protection Regulation, which also uses access to the internal market, and which she has coined in her new book on the digital empires, also more looking beyond the EU, to make this argument that in governing, let's say, the global digital world, you have different regulatory powers that try to govern and regulate technology, with the EU being one of them, the US being another one, and China being the third one, and doing that all through different types of regulation. So that's one of the contexts. And relatedly, John Scott has been pushing from a more legal perspective, really going into the dogmatics of European and EU rules, EU regulations, to show what kind of, she calls it, extraterritorial triggers the EU law has that binds essentially actors outside the EU. No? For instance, the criterion of accessing the internal market now becomes an important perspective. Then we also have relatedly discussions in public international law on sort of new geopolitics, international relations. And here also the discussion on the EU, Luc van Middelaar calling the EU's geopolitical awakening to also gain global political dominance. And then also, of course, this discussion, which I think is much more familiar also to most of you public international lawyers, also the division or discussion of global north or global south perspectives. So where do you put what actors is there? Is it US, China, and the EU? Is that really an adequate description, or do you have to take other distinction, also other power relations within the EU? But very much centering the regional organization and the public actor of the EU, China, global north, global south. What role does Africa play in this picture? That shapes the debate. So, and in contrast to that, and I think this is where it gets interesting when you look into the private law discussion on, say, global and transnational private law, you see almost an absence of states, and regional organizations. So, I mean, I think the book by Katharina Pistor on the constitution of the global financial system, the coding of capital. I think she wasn't the first one who said it, but she was at least the one who has been making it very concrete, and that can also be a benefit for then shaping the debate, because it has been influencing also a lot of also other disciplines, economics, etc. So this idea here we have a private law, the core, which she calls it the modules of private law that constitute the global markets and that are relevant for as a way to distribute wealth, create inequality. And we can boil this down to the contracts, we can boil this down to property, we can boil this down to the corporate legal personality and legal limited liability. But in her analysis being very, let's say, state absent. She mentions state a lot of times, as the background enforcement mechanisms. Those are that critically, are landing, let's say, the enforcement power transnational contracts. But it's states. It's also not different powers. It's not, let's say, a territorial, territorial understanding, if at all. And this is, let's say, a bit anticipating my last point. She's making the argument that there's essentially two types of private law that govern that govern global financial capital, and that's essentially London and New York, and it's essentially the common law that is doing this job. So there exists nothing. If I'm now sort of being a bit simplistic, there's nothing about the common law that constitutes global financial market. And when you look into private law and also private international law scholarship, you have a lot of discussions about, let's say, subjecting laws of forum shopping, subjecting laws and regulation that different regional organizations or also states make to private shops. Very early on, Robert Wye has called this as the transnational lift-off. So where you have, let's say, a internationalist movement, so where global contracts, private contracts are essentially subject to the choice that the parties make, so in terms of the merits of the law, but also in terms of the dispute forum. And in the so I'm going to come to that. The whole concept that I'm talking about European transnational private laws from a book that we're soon publishing. One of the contributions was from Anna Chadwick, who also is in the UK in Glasgow, who has been writing on global financial market, who has been portraying this as the EU law being and EU being on the market, so of choice, and even more so of the transnational regulators that say, just been very sort of meticulously tracing how the EU is essentially adopting financial market regulation in response to global frameworks. So how the ICA Master Agreement has been shaping the way in which the MiFID regulations have been set up. So where you have very strong, say, states being subject to private choice. So these are, let's say, the two satellites that I'm using. So private law being very apolitical, if you want, and being subject to business choices, constituting global markets. And on the other hand, you have a strong discussion now on regulation and competition for regulation of different geopolitical powers. And this is what has led us to sort of, let's say, our context of inquiry to look into, is this really true? No? So is really sort of private law, no? So we have an apolitical private law, and we have states that use regulation, or are these modes of private law, these different, if you want, heritages or modes, national modes also of private law, how are they used and relied upon to constitute global markets? So is it, what type of private laws is it? No, is the common law and everything else, or is there a bit more strong differences between different types of private laws? And this is, I think, this was the core interest, and also how does this discussion on who's the global regulator, who's competing for technology on digital markets, on supply chains, financial markets, how do states and regional powers use private law to gain global influence? So is this really sort of only about regulation, or is this also about private laws, or in a sense about regulatory private? And the question that we also asked was to look at not private laws pays emphasis or puts a lot of emphasis on the role of private actors. So the question of what role do contracts, standards, codes play, codes of conduct, so private codes, play also in gaining global relevance, and to what extent is this maybe also linked to certain states now. So and there, what you see in the EU very strongly is piggybacking on, for instance, technical standardization bodies in the EU to also get onto, let's say, global influence in standards. So which is not, let's say, the typical political way. It's not the typical way in which, say, international treaty making would work. It's a way of so using and giving their own private actors that are receive public functions a stronger role in influencing global standard setting. And of course, and this is where it becomes more a question of where does the description start, and where does it end, and where does the normativity critique start. Of course, these questions then always are related to what is included and what is excluded. So if we now do not divide according to sort of states, and don't see the power relations only in relation to states or regional organizations, we have to ask different questions of inclusion and exclusion. So if the EU is piggybacking on global supply chains and using the contracts to oblige its corporations to perpetuate certain considered EU values onto global supply chains, then the questions of inclusion and exclusion operate along those supply chains and not necessarily along the territory. So then it's not does the EU exclude certain countries, but it's more, does it exclude certain sectors and hereby also certain communities. But I think I'm gonna go mostly at the end of the lecture. Just to give you a quote, I mean, my colleague Paul Kier, he's interested in quite similar question also, where he speaks about fragmented globalization implies that those with the will and the resources to do will establish their strategic autonomy by creating their own worlds. So they create their own their own supply chains, their own digital spaces, that they regulate worlds which, I mean, he's very much into social theory, so that's why it might be a bit complicated. But worlds which are internally synchronized through institutional regimes, so setting up of specific mechanisms, and where exchanges with other worlds are conditioned upon institutionalized filtering processes. Now, from the internet to supply chains to financial markets, technology and energy, as well as literally all other areas of importance, having one's own becomes the mantra. So where you have, let's say, worlds that are not synchronized or not differentiated according to territory, but according to subject matters that are considered of importance. And here I'm getting to my, let's say, main point. So all of this, what I'm discussing here, this idea of linking, sort of public and private, linking European to transnational and private law, is a book or is a project that I have been working on together with a couple of colleagues, which we're going to publish, and this is why I'm presenting it the first time. The book will be published, I think, in 1 or 2 months. So this is really sort of the first time I'm presenting it. Where we take the perspective of the EU. No? So you have to bear with me. I'm going to use examples, of course, from the EU. And indeed look into EU private law and European private law. I would say a few words on that as well. To integrate private law and transnational law. No? And transnational law, our idea was to say overcome a bit the public-private divide and also put our emphasis on private actors, no? And sort of to connect the almost old debate on not transnational law as a autonomous private system that shapes also normativity on a global level, and to see to use this concept and this notion and the whole debate related to it to expand our thinking of what type of actors can you look at and what type of processes can you look at. No, it's just the EU employing concepts that it considers to be formally related to private law, or is this also a way to look at processes where private actors are shaping, and what European private actors are shaping and trying to gain dominance. We focus on the EU perspective, and as I said, this is it's also something that we have been quite strongly and intensively debating. So it's a lot of what we discussed and a lot of the examples, of course, that we use are related to the EU and to say European heritage. And our discussion went so far that we weren't, in the end, we were a little bit divided on whether our concepts and our conceptual apparatus of defining private law was actually so much tied to the EU that you might not even be able to translate the concept of European transnational private law into other fields. No? So the question is, to what extent is our understanding that we put forward and that we discussed private law and one that is European, or is this a universal concept that you can apply to the European sphere? We understand it mostly as a, let's say, analytical concept, so as a heuristic to see, to allow us to see and identify certain processes, and maybe invisible processes if you of such sort of trying to gain influence. But of course, we all as lawyers know it's very difficult to detach the normativity from the description. So of course, it's also there is a follow-up discussion to what extent there's a certain legitimizing factor in it, by portraying it in the way we do. Methodologically, the project has very much moved as a sort of using the repository of our network, and we have been collecting contributions from a number of fields to make sense to see whether we have been or to put it on a broader basis, and to see where are we putting our fingers as the right areas. Of course, let's be open on these methodological aspects. If you started with such a big collaborative project, it always there's certain idiosyncrasies and certain coincidences that are difficult to avoid, and that of course also provide sometimes also biased perspectives on the topic because you haven't been gathering a certain contribution and you haven't been consulting a certain expert, or because the people you have been working with provide a certain or stand for a certain direction or school or strand in the debate. And I think in our case the most relevant one is that we have been working very much in this tradition of regulatory private law, which also is one understanding in, let's say, in the EU and in European private law, which is also, but which is not universal, no? So it's not one that, that everyone would accept, no? So that there's the private law is also is regulatory, that it's related to regulation, that it's applied, and that's sort of questions about the public-private divide, but that's something that comes from the origin of the project. So let me a bit unpack this concept. What do we look at? What does it allow us to look at? And here, yeah, I'm just looking at sort of the different components. So I said a couple of things, but I'm gonna go a bit deeper now. So European, no? So as I said, we're looking at European transnational private law. So in that clearly is, I mean, you can, it's a geographical perspective, no, that looks at Europe, no, or maybe also historically at a certain area, a certain type of thinking, a type of legal thought. But we have always been, let's say, working on this twofold perspective of European and the EU, no? So looking at the European member states, so how is their private laws, how are their private laws playing a role, and the EU, no? The EU as an own actor. No? And if you, of course, for instance, focus primarily on trade policies, and of course the EU comes much more to the forefront because it's the actor that is concluding that in trade policies, whereas when you look into private law, most of the private laws and the general rules of private law are still matters of the member states. No? So within the EU, there's also competence division. And if you look historically, of course, I mean, it becomes much more complex. So then you might also need to draw different boundaries. Yeah. Then, as I said, we added also a European private law. We added to that transnational private law and not European international private law, not only because international private law would suggest we're talking about private international law, which you don't. I mean, that's a problem you generally have, but also because we wanted to open up, as I said, the conceptual apparatus to also and specifically focus on on transnational relations, and to open up the public-private divide, if you want, to also include actors that are normally not seen, no? And yeah, when you have more international relations perspective, no? Where you look at mostly those actors that operate on an international scene, that's not mostly states and that have international subjectivity. But in transnational law, there's to an extent, of course, also questioning then the boundaries, so where do you stop, including actors, but it very much puts this emphasis also on the autonomous rule-making of private actors that are not necessarily formally recognized. Yeah? So global corporations as setting their own standards, or technical standardization bodies setting standards, no? Contracts and contractual, international contractual customers. And then we have the sort of the concept of private law, and this is what I'm going to mostly focus on now in the remainder of my presentation. Also, the question: what do we mean with private law? What kind of private laws do we do? Are those that are used, that are so where certain political influence is transported? And here, that is also one of the core of my contributions. You may also say these are concepts that very much come from Europe, so why it might be that this is why you have a very European-centric understanding. So I'm also open to being questions on that, and criticized on that. But to look at, essentially, I call it three concepts of private law. Leo somehow it's been sticking in my hand, and I'm still looking for some of them, at least for the first one, for a better term. So what I call formal private law, where what I intended to look at is really sort of the formal way in which contracts are formed, the rules of contract formation, the rules on the institutions of contract law, institutions of property, institutions of tort, so these, let's say, classical legal institutions that form the core body of private law. No? So as a formal way that do not necessarily look into politically influencing them, although you can of course argue that implicitly by fostering certain and enforcing certain types of contracts, you have an implicit political value, but no, this let's say traditional old understanding of private law is the law for businesses, and it's about enforcement of contracts. So this as a first category. And then as a second category, this sort of movement that you had in most European states, but also more outspokenly in the EU towards regulation or relating private law to regulation. So which is linked to constitutionalization of private law and also the influx of human rights into private law thinking on an EU level, and also this use of private law to achieve certain regulatory objectives. And the third one that I call societal private law, so maybe a little bit of my own background, intellectual background, coming from the Teubner school. So now I'm in, Gunther Teubner has been very strongly coining this concept of societal constitutionalism, also societal private law. So private law that where law is understood as a broader concept. So the contract is the law, not necessarily the state lending its enforcement power, but it's creating its own worlds. It's the private actors that create their own, you would even say, constitutions. So I'm not going to go into that. But which also really strongly puts our focus onto the role of private actors. And so what companies, how are companies creating laws? How are contracting partners, commercial contracting evolves as a world in its own, as a regulatory world. And of course, and that's what I'm getting at, is that the idea of societal private law is very much us, state, non-state oriented, us, and almost criticized as rejecting states in its entirety. And with our notion of European transnational private law and the societal law, we put again, let's say, the states back in, to see how the geographies back in, to see how it's not the corporations that govern globally through their own rules, but there might be a version of European corporations versus UK corporations or English corporations or versus African corporations that influence all or create different types of worlds. So it's not that you have, let's say, one societal institutional or one society. So when we look into formal private law, this is the competing seminars. This type of formal private law, you can of course look again at these modes of expansion in a different way. So you can look at historically, that's what the colleague Gillian, she's a legal historian, she has been working mostly on this, to look at how certain modes of thinking for private law historically have been shaping global relations, how they have been exported. And I mean, in Europe, of course, there's this dominance of thinking through the lens of Roman law, but also to think of alternative ways what can be what you can classify as private law, but what type of institutions this could be. So what. But this is the question is, of course, how far do you go back in history? Where do you have that type of expansion? But what is interesting, and that's what I looked a little bit more into, is this idea, which you mostly had on the European continent at some point, of formalizing private law through the adoption of civil codes, and this sort of comprehensive understanding, which was taken also to the EU, which at some point seemed to have quite a significant influence in the way, global influence in the way in which private law was understood, in which it was formed. But also, and interestingly, when you look into the more recent developments, the EU has been making internally if you remember this, what they call the draft common frame of reference and the different principles of private law, to harmonize and find a common core within Europe on private law, which has completely failed, because it hasn't, so partly, of course, because of the common law civil law divide, but also because it's, because it's an academic versus a political project. But it has been, this idea of a codification within Europe and this uniform codification in private law hasn't been very strong. But then you see popping up outside of the EU in the aftermath, and partly if you trace back the academics that were involved in this, similar projects in other parts of the world. So you had the principle of South American contract law, you had principles of Asian contract law. So, and as I said, if you look into who was involved there, and it was also many of the European thinkers that were involved, not only the DCFR, but also in these principle making common core projects in Europe. So that's a quite interesting. But then, of course, you have, when you look at, let's say, the export of former private law, the EU, and also mostly of the civil law countries, had now recently, I would say, rather limited influence. We had a colleague here also from the UK who was talking about arbitration and private international law, was saying essentially, the EU hasn't been really sort of trying to gain dominance in international commerce. It has been sort of leaving the place to the common law. And the common law has been a very strong law that also there's enough empirical evidence now showing if you have international contracting, if not one of the states or one of the contracting parties is chosen, so what's the most neutral, considered neutral law that is chosen? It's like in most cases English common law. Swiss law is sometimes also chosen, but so you have a strong dominance here. And when you look into, let's say, how the EU has been using or trying to influence this, you see very little, but then you see in the sort of what I would call a bit of a hindsight intervention. I call it the drawing of red lines, where you all the frameworks, including the private international frameworks in the EU, allowed all these sort of party choice and allowed hereby sort of a strong limited relevance of EU law. But then when it came to the enforcement of arbitral proceedings, also to choice of law agreements, the Court of Justice on several occasions has been interfering into also on the grounds of public policy, and saying this is where you have to adhere to certain legal, to EU law standards. So I would say sort of historically, maybe you can find influence depending a bit on the concepts you use, but in the more recent history, sort of these formal private law ideas, the EU hasn't been very successful, but then has been drawing these kind of red lines in the aftermath, saying. And then, then when we look into regulatory private law, so private law that is used as part of regulation, where as part of market regulation, so where you have, say, liability provisions in there, you have control of contract terms. That's in the EU already quite the main terrain of the EU, so regulating full private law. But here you also see very strongly the attempt at least of the EU to gain global relevance. And I just giving a couple of examples. So now one of our editors, Hans Mieglitz, has been doing a large-scale study on the integration of consumer law in various parts of the world, and looking into how they see and he sort of found out that there's a strong use of, let's say, specifically consumer law in many countries of the world to look up to the EU on how they have been creating consumer law. And then we had a contribution on anti-discrimination, which is the complete opposite. Which is also within the EU a strong component of regulatory private law. So these regulation of employment contracts for anti-discrimination, where the European Court of Justice has been interfering on several occasions, for also horizontal application of the Charter, but which you don't see being reflected that strongly. So there's also an interesting comparison to do and to see sort of, okay, maybe let's say consumer law is a bit it was one of the core areas in the EU. So one was the earliest private law domains as well, where the functioning of the internal market was always fostered by and pushed through in the field of consumer law, which also shapes to a large extent European private law. And you might think that this might be an argument or a reason why consumer law also has been quite advanced in the EU and has been used. Or also because the EU, of course, is a big consumer market, and that would be another aspect. So that in terms of, let's say, modes of, and also where you have, let's say, export or reflection of private law concepts in the EU outside the EU. But what you now recently more strongly see, and I think this is where private law also becomes very interesting to look at from the regulatory perspective, is that it's integrated in these regulatory modes that are, according to Scott terminology, are extraterritorial triggers. So in sustainability, you have it very strongly now with I think today they finally adopted the Corporate Sustainability Due Diligence Directive, which is not only, let's say, a regulatory directive, which also is relevant for societal private law, but also one that has a clear liability provision in there to try to attract the disputes that come now under also about human rights and global supply chains to the European Forum, including by integrating or considering this directive as an overriding mandatory provision under private international law, that you cannot opt out, or that cannot be opted out. And this is also, when you politically look into the process of this, it has been quite has been a quite strong impetus and strong discussion and controversy about how to use liability and private law. On the other hand, also sort of in the sustainability debate, you also have rules that now start to interfere into contract, into transnational contracts, in terms of fairness, using a European fairness standard. So in unfair trading practices, you have that now, and for food supply chains, that the EU says if just one of the parties is located in the EU or has a strong link to the EU, then these types of contracts are controlled as to fairness considerations, with an enumerated and with a regulatory model, with a blacklist, blacklist of practices, which very strongly comes from the EU consumer law. And you have it similar also in digitalization policies when you look at the newly adopted AI Act. I mean, subject to the less textual revision, you now also have you have not only regulation of actors if they supply, if they provide and put on the market so-called AI systems, but also an internal attempt to regulate the different actors in the AI value chain, including which goes outside the necessary, or is not limited to the EU territory. So here, when you look at, let's say, the regulatory private law, using private law also as a means to for regulation, you have a stronger, I would say, stronger, also influence and attempt to influence. Then my last point, so when we look into private actors and let's say their own legal systems, if you want, or quasi-legal systems, as I said, this so much coined as societal orders, and even societal constitutionalism, where private actors might depart from the state and might produce their own legal orders, the multinationals that produce their own legal orders, the technical standardization, I think I've mentioned it over the presentation. And this is, let's say, where if we use, let's say, European transnational private law in the societal dimension, the argument is we may see that there are differences. So that there are differences between different types of multinational corporations and how they what type of orders they create. And here you see very strongly not only the European actors, also what they the European private actors themselves creating their own orders, but you also see, and here I'm mentioning again, let's say, three central pieces that the EU has been developing. We see almost piggybacking on private actors. No? So we see the different, not only the EU, but very strongly the EU, in trying to access and to get global dominance by requiring their own corporations here to do due diligence, in global supply chains, and hereby include in their contract certain, what the EU has defined as human rights risks, sustainability risks, and to use the contract as a mechanism and the global ordering of European multinational corporations in exporting and you see, I mean, in the AI Act, you see similar rules. So by constructing and say piggybacking on the AI value chain, the different functional actors that are related, and using and not only imposing certain obligations, but also asking conformity checks, risk assessment. When I forgot the Digital Services Act, that now has delineated certain online platforms that are all not located in, they're not incorporated in the EU, but they're operating on the EU territory to now make huge risk assessments in their online environments, according to what the EU has defined as risks. And to that, of course, we have also battles over technical standards, certification, all actors that are generally a little bit outside the very invisible. I'm not the one who has been working mostly on technical standards. It's one of the most dry areas you can get into. But we had a couple of discussions and also a chapter on technical standards and how you have, even in these sort of dry they mean a lot, these technical standards, how you have competition between technical standardization organizations, also on a global level. And here now, very recently, the EU has also been for a long time now also using technical standards in its rules as for compliance checks, for certifying compliance. And the ECJ has now been very strong in pushing for publication of these standards. It's very powerful to impose on, say, okay, these are might be private actors, it might be private orders, but if these are related to the law, if they're part of compliances in the law, they need to be published. And of course, these whole private standardization bodies built on the model of not having these standards published, and also having receiving money for getting access. And here, they use very strongly pushing for this whole standardization world, if you want, to be public and to adhere to publicity standards. Which would be interesting to see sort of how this will change also global standard setting practice, or whether it will. I'm not sure how much I'm in the time, but I can go on. So this is, let's say, the analytical heuristic that we have been discussing and that we have been setting up, so different ways in which private law is used globally, and where it can, where we can see influences or we can investigate influences. but of course, sort of it begs the question of what are the consequences? No? So what do we have to look for? What does this mean? What type of consequences does it have if we apply this type of notion, if we take this type of perspective? And I think one of them is indeed that so you might find different variations of private law all parallel acting or being present on a global level. And not necessarily according to, that's where when you take the private law lens, according to territories, but according to, let's say, functional markets delineation. So in the sort of the value chain regulation, if you might have Chinese, EU, US, UK versions of value chains. That is, let's say, what we can see with these type of concepts. Another aspect that we can see, and again, but using the example of value chains, is of course then conflicts of laws within these private law structures. So the moment you're piggybacking on private actors, I mean, these might be accessed by different forms of private law. And to give a concrete example, and also if you have global value chains that are now becoming, say, a tool of regulation, you end up having a supplier supplier relation in one country being exposed because it's accessing, it's part of different value chains to comply with the US imposition of US rules as well as EU rules, and not directly, but in the transformation within the private corporate structure. Because the EU is also not, it's piggybacking on value chains is of course an idea to use the contract and use the order of the multinational in the European multinationals to export its own values, its human rights understanding, its sustainability understanding. But at the same time, these are all translated into risk management obligations. So they have to corporations have to make sense of them, and it's quite interesting to see how then they make sense of this. So you have, let's say, European versions of multinationals versus Chinese multinationals that all come together in contracts in a value chain where you might have conflicting expectations. So labor standards is of course a very good example, where you have, let's say, the Europeans and tell their corporation that trade association, freedom of association is an important component. You have to ensure that this is also integrated throughout your value chain, and then you might have other countries say, but it's prohibited. And then all of a sudden, it's also then you start to have conflict of laws that are where corporations start to manage this kind of unclear boundaries. So you have a kind of conflict of laws within these transnational private structures, and the question is, what kind of conflict of law do we need to understand these and finally, I promised a bit to end with, let's say, the normative or maybe also critical analysis of what does this mean? Also, if we have now also questions of who's included, who's excluded globally, not maybe along territorial lines, but along functional lines of operations, of markets, of value chains, of digital environments. We might have to ask the question of inclusion and exclusion differently. So we might, and one of the, Hans Lindahl in an early paper on illegality has been already coining this idea of multinational corporations as he calls we in the first person law as a first person plural, which draws boundaries of inclusion, exclusion, and legality, illegality. But it's very hard to deal with illegality, so this contestation of structures. And one very interesting piece that I'm mentioning here in full, because I think it's one that puts in the context of critical trade approaches the issues very strongly on the table. is Caroline Omarine-Kluma's work on trade critique of value chain regulation. And I think it's interesting because I think she starts off with if you want a classical trade critique, and say, okay, this is sort of the laws made in the first world. It's that now sort of go on and to regulate value chains, and what does trade have to do that? And then she ends up in asking all these types of questions and putting out, like, say, new concepts of we're not then talking about, let's say, or no, we have to transform our understanding from the trail countries to the communities, the communities that are affected by global value chains. We have to give those communities a voice, these affected stakeholders, and she's also very strongly in the political debate on due diligence legislation to say, yes, it's important that we have, let's say, we consider this exclusion and not as it is at the moment, and we need to integrate these excluded participants. So it's not about do we have to include where the power structures in a global north, global south country, which countries belong to the global north, which to the global south, where are colonial continuities. I mean, this is also an important question, but in this context of regulating through value chains, we have to look at functional powers, and we have to look at functional exclusion. So these are, let's say, the big questions that come up and that we have been putting out on the table. So we're not, maybe we're also not, I didn't want to sort of provide all the answers yet. But I hope that I have sort of shown that it can be an interesting way and an interesting concept to look at global power dynamics, to find also an entry point that provides more the invisible power dynamics that you might not see if you mainly focus on countries, or if you consider, let's say, the global markets and the global financial system, but you see sort of how all of this is intertwined and produces quite strong concepts. And I think I have no idea whether I stayed in the time, but this was what I was wanting to discuss, and I'm very much looking forward to discussing it. So I'm also quite excited to see whether this resonates or not. Thank you very much.
I received a message that we have 15 minutes before the reception's all set up, so we could begin the conversation here for 10, 15 minutes and then migrate over to the wine and keep the conversation going. Would that be okay?
Absolutely.
Wonderful. Can we take we can take a round of applause?
I'm sure there are many.
Yeah, we have Abu, Luke, and Yusra.
Yeah, I'm happy to go first. I think it's quite maybe just a silly question, so be my naivety and my ignorance to this area of law, which is not my specialism. But I'm quite interested in understanding. If I understood you correctly, you suggested that the European Union historically has left this area of private law within the competence of member states. And I suppose my question is, do you envision that remaining the case, or do you see, as part of this idea of the ever closer union, that the EU is slowly beginning to encroach into the sphere of private law and trying to harmonise more across its various member states? And obviously that's from the perspective of like a public lawyer, and we've been through the Brexit process in the UK, and these were the sorts of arguments that were being raised in that discourse.
Should I can take it out, and we have time. We can take one.
I should decide.
Yeah, it depends a bit. No, if the questions are unconnected, then it's easy to use one. So historically, I mean, the EU historically only has competences in certain areas, no? So that's why it didn't leave it to the member state. It was just not a competence in the EU, no? So it was always the private law harmonization, mostly run by the competence of the functioning of the internal market. So that's why also you have a very different form of private law happening in the EU. Whether this is going to change, I don't think there will be a new harmonization effort. I mean, they're burned. They have tried in the beginning of the 2000s. This was like a big thing. You now had like one prominent private lawyer, Martijn Nesseling, has been making a call again, manifesto, for a new European civil code. But a principle-based one, and one, of course, that is globally relevant and that also takes into very critically oriented. And he has been discussing it quite extensively with a number of private lawyers, and I think he got a lot of critique on the feasibility of this. No? I mean, of course, now having, let's say, in private law, of course, not having the UK and the EU makes things a little bit easier. I have to say this, because this is the biggest common law country, and one of this device that always took place in private law harmonization was the divide between common law and civil law. So that's it. I don't say generally that I don't want to support. I would love to have the UK back in the European Union, but this is one has been let's say so. Hindering a lot of private law processes, but I don't think it's going to come back. But what I think will come back, or what I think is coming, is this sort of when you have the integration of private law concepts now into areas of competence of the EU. So, and sustainability due to the AI Act, where you now like infiltrate private law concepts. This is going to do something with private law for member states. So, and yeah, the question is how this is going to be taken up on national level.
Thank you so much.
Okay, so thank you for the Gillian's presentation. I've got just two questions. So the first one is, do you think the EU transnational private law is a viable project, considering the fact that somewhat similar, projects like the codification of the contract law failed? So is it something different from what you're proposing now? So that's number one. The second question is this not also another attempt by European scholars or legislators to impose certain European values on the rest of the world, just like they did for lex mercatoria, which is something that is entirely European, but described as transnational commercial, which everyone is expecting to adopt. So is it like something similar to that?
Yeah, so it's not a codification project, and I think so. Our project is not. It's not a political project. It's also not a project to have a whole body of private law, sort of that we can universalize. We see it really as an analytical inroad to understanding certain processes, and attempts of global dominance. And I mentioned it, and that's maybe related to your second question. This is not another version of European imperialism. I mean, maybe it is. Maybe we can show with this that there are attempts, very partly outspoken attempts, but also partly very invisible attempts. And I think this sort of end where I said and we can discuss on whether by coining these types of concepts you're already legitimizing them, and you say, okay, this is. I wouldn't go as far as that. I would say these. So for one, I'm happy to be challenged from other parts of say, so okay, this is a very European version that also holds only true for these areas where the EU is trying to gain, or Europe is trying to gain dominance. So that for one, but for the other, I think it may help us to show and also to have a critical inroad to this European, newer European attempts to use its corporations, its multinational corporations to impose standards on the rest of the world. And again, sort of my last point on the trail critique of transnational private regulation. I mean, that is something where I would say we have been sort of putting out an idea that can also be used to critique and to show sort of how critically analyze how, for instance, the EU is using its internal market disciplining outside the world, but it is doing that. You know? That's whether that's a good thing. I'm quite, in many ways, quite critical also on these due diligence efforts and these. You see the strategic autonomy, this sort of disciplining global supply chains for disruption risks, which is, let's say, putting power continuities onto private actors where it probably shouldn't be. But the question is sort of who do you empower and who do you have to consider there? And there the question, this concept would suggest maybe we need to look at those functionally related to certain value chains, certain sectors, certain markets. So it's. But of course, that's a fair critique on.
We have two last questions. We have Yusra, Javi, and Justina, and then we'll wrap up.
We have 2 minutes. I know we have 2 minutes until it starts.
Yusra?
Thank you so much. What a great presentation. Thanks so much for being here and for sharing your new research with us. So what this made me think about, and feel free to tell me if this is not at all relevant, but so one of my research interests is climate change and the international environmental law. And it's made me wonder, because these days in the environmental space, we're talking a lot about tort liability for private actors in the climate space. And I just wondered if there is, are there any new kind of regulatory effects in the EU about this that you can speak to? This is relevant, but yeah.
Definitely. Climate change is also one of them. Also, the European Green Deal is one of the major, let's say, regulatory projects in the EU. If you look into litigation against, so the litigation against companies, there has been a draw to Europe as well. Over in particular, my country, the Netherlands, has become a bit of a foreign convenience for these types of lawsuits. And some of them are also because they are based on partly broad readings of private international law, European private international law, and also where is the event giving rise to climate damage? Where the Dutch court has said it's also in the Netherlands where the main decisions of Shell are taking place. So where, so in that sense it is relevant. But again, sort of speaking to the inclusion-exclusion question, I know because I think it can tie nicely. If you take this case, for instance, the Shell biodiversity case, on the one hand, also has been praised as like a big climate case in Europe that has been also made possible by the open reading of Dutch tort law in terms of integrating international standards. But at the same time, when you read the judgment carefully, how does it frame the litigants and those affected by climate change? Caused by what Shell has been looking at the Wallen region and not at the overseas kingdom of the Netherlands that is mostly affected by climate change. So you also see how in these, say, European versions of private law, you have again so certain exclusions, certain European versions of. So that in that sense, this is also it is also very relevant. I hope this helps in answering.
I'm happy for Justina to go first. And then
Well, sure, that's one.
well,
Thank you. That was incredibly interesting. I learned a lot. It's interesting how post-internationality operates because the first time I heard strategic autonomy to create worlds, to me it also sounded like a modern code for imperial practices, let's say. But more like a modern code for imperial practices.
Yes.
Yeah. But regardless of that, I would be really curious to know from your perspective with which actors is the EU, like where and with whom does the EU want to create this kind of alternative or autonomous work, especially with, I do not know much about this, but yeah,
hearing how China is gaining such a strong foothold in Africa and in South America. And then the other question that I had, I was really fascinated by this idea of reclaiming the role of the state in private law. I was wondering to which extent this analytical way of describing the piggybacking of the states on other companies is cannot also be seen, let's say, as a concession. So is the state, let's say, foregoing a lot of power in doing that? And if I made the last comment, Queen Slobodian was last week at the UI, and perhaps you have read his most recent work. I hadn't, but I think that, well, now he's doing this history of anarcho-capitalists and the way in which they create liberated zones. So tax havens, board with different regulations, he also spoke about this project that was under consideration in Honduras of creating different cities where, so I think that perhaps this would be really relevant to, Thank you so much.
So partner, okay, these are difficult questions. I mean, partnering with who, and also, of course, this is also a question partly from a more geopolitical perspective. I think in what we have been looking at, it's also, this concession, quite a lot of concession to private actors, and sort of delineating, dispersing their global supply chain. So you have this in the strategic autonomy package. I mean, there's two, let's say, I would say roles. So one is trying to get the capacity built up in Europe. So that's the autonomy part. On the other hand, to impose on private actors risk management obligations for diversifying their supply chains. And I think conceding that it's mostly private actors that are going to do this. So you have and there's this Critical Raw Materials Act and the Critical Entities Resilience Directive that both impose like risk management obligations, so for certain considered important, strategically important and infrastructurally important actors, private actors, to monitor and to have storing capacities of their stock to ensure that in terms of disruption there's diversification. So I mean there is probably a geopolitical part to it too. So which countries does the EU mostly work with, which is not necessarily what I'm an expert in, but there is also this moment of this strategy of relying on private actors to diversify and to use their own worlds, let's say, and whether this is in Nigeria or whether this is in India, doesn't matter so much in this.
Okay, thank you very much, Anna, for a very thought-provoking presentation. I thought it was brilliant. I'm conscious that
the reception you all about.
Yeah, I'll be very brief. I very much enjoyed it. Then I am fascinated by the whole notion of private law, even as a public lawyer. I'm not a great believer anyway in the traditional divide. I've been very critical in my own research. Could you explore a bit further what you mean? I know this is a big question by private law here, because you refer to contract law quite a lot, even using it by example. I know it's a much wider label, but I think there are significant differences, understandably, between contract law and I've done some more work in the area of family succession law. I think harmonization in those fields is really, really challenging, definitely not something I would include in your project. And I was wondering whether you could give us some support in that particular area. I was very interested in your use of the concept formal law at some point when you when you said I'm still working on the label and do you really mean perhaps procedural law? Is that what you are thinking of? I was just wondering. Anyway, but thank you very much because it was really brilliant.
That's a broad question. I don't understand contracts and
Because it's contract your main research.
Yeah, contract and
expertise.
ports is the
Yeah,
two
yeah.
main areas. No, and I think family, if you include family and succession, I mean, these are some of the private law areas that have
It's not private law.
yeah, and then they have their life on their own. Yeah, in some countries they are linked to private law. They consider to be private law, and but I think in our project also, I mean, the focus was automatically on, let's say, the general law, obligations, and tort law, because that's also the one that where the EU had the strongest, let's say, impact, also internally within the EU. You're getting your familiar terrain, if you know. Ask your family about it.
Yeah. That's great, thank you.
It's such a delight to have you, Professor Beckers, with us. Thank you for everyone being with us this evening. Why don't we keep the conversation going in the other room? Thank you again.
Thank you.